The Reid policy on the use of deception during an interrogation. In this program, we will discuss four components: several court decisions on the use of deception during the interrogation process, what social psychologists say about misrepresenting evidence during the interrogation, recent state laws that have been enacted which prohibit lying to juveniles during an interrogation about the evidence, and the policy we recommend for investigators on the use of deception during an interrogation. The foundation of the Reid technique rests on several core principles, which I like to enunciate as the foundation of our discussion today. We always want to treat the subject with dignity and respect. We always want to conduct interviews and interrogations in accordance with the guidelines established by the courts. We do not want any investigator to make promises of leniency or threats of harm or inevitable consequences. Investigators should not conduct interrogations for an excessively lengthy period of time and should never deny the subject any of their rights. We do not want to deny the subject the opportunity to satisfy their physical needs, and we want to exercise special precautions when questioning juveniles or individuals with mental or psychological impairments. So let's take a look at some of the court decisions and how they address the issue of misrepresenting evidence to a subject during an interrogation. The leading case on the topic is 1969 Frazier versus Cupp. In that case, the United States Supreme Court upheld the use of misrepresenting evidence. They upheld Frazier's confession, which was based in part on the police falsely telling him that his accomplice had confessed. In their decision, the Supreme Court held that misrepresentations of evidence were relevant, but they did not make an otherwise voluntary confession inadmissible. In reaching their conclusion, the court said you have to look at the totality of circumstances. Now, it's important to highlight the court's reference to, quote, an otherwise voluntary confession. The clear implication being that if the subject's rights were honored, if there were no threats of harm or inevitable consequences, if there were no promises of leniency, if the investigator followed the guidelines established by the courts, then misrepresenting evidence in and of itself is not likely to jeopardize the admissibility of confession. It's not likely to make an innocent person all of a sudden confess. Several other courts have followed along with similar assessments. For example, in State versus Colts, the Vermont Supreme Court upheld the admissibility of the defendant's confession that in part was made in response to the investigator's false statement that there was DNA evidence proving his guilt. The Vermont Supreme Court said that the detective's false claim of DNA evidence is not enough to render this confession involuntary without other coercive actions such as a promise of leniency. And the court pointed out, in this case, the detectives made no promises of leniency. In Anderson versus Vinoy, the U.S. District Court upheld the lower court's decision not to suppress the defendant's incriminating statements, stating in their opinion that a detective misled the defendant into believing that the police knew more about the case than they really did by claiming the victims had identified him. The court found that the detective's statements to the defendant were not sufficient inducements to make this otherwise voluntary confession inadmissible. In Commonwealths versus Gillette, the Supreme Judicial Court of Massachusetts upheld the admissibility of the defendant's confession. The defendant claimed that the officers misrepresented evidence that strengthened their case and induced him to make an incriminating statement. From the court's opinion, quote, we conclude that the officers did not act impermissibly. We have suppressed a defendant's statement in circumstances where police use trickery or a ruse in obtaining the confession, but those cases generally have additional circumstances, apart from the ruse itself, that rendered the confession involuntary. And the court went on to describe those additional circumstances as coercive tactics relating to the defendant's son, minimizing the legal gravity of the alleged crime, suggesting to the defendant that if he did not confess, he would be charged with a more serious crime, and after the defendant invoked his right to counsel, dissuading him from consulting with a lawyer, and implicitly promised leniency as well as alcohol counseling if he went on to confess. In another case, State v. Johnson, the Court of Appeals of South Carolina upheld the voluntariness of the defendant's confession, indicating that misrepresenting evidence is not a coercive tactic. In the court's opinion, they stated that misrepresentations of evidence by police, although a relevant factor, does not render an otherwise voluntary confession inadmissible. The pertinent question is whether the defendant's will was overborne. And finally, consider the court's opinion in U.S. v. Graham, in which the court pointed out that misrepresenting evidence is one factor to consider among the totality of circumstances in determining voluntariness. The court stated that there are a number of cases in which statements elicited from a defendant in response to police deception were found involuntary, but pointed out that these cases all involve significant aggravating circumstances not present here, such as subjecting the accused to an exhaustively long interrogation, the application of physical force or the threat to do so, or the making of a promise that induces a confession. So there seems to be, for the most part, a consistent consensus of opinion by the courts that lying about evidence in an otherwise voluntary confession will not render the confession inadmissible. It's the view of these courts that behavior such as threats of harm or inevitable consequences, denial of rights, promises of leniency, or other such coercive behaviors will jeopardize the admissibility of the subject's confession, but not simply misrepresenting the evidence in the case. Now, I will point out the courts have drawn a distinction between verbal misrepresentation of evidence and fabricating physical evidence, finding, of course, that fabricated physical evidence is unacceptable in all circumstances. One of the cases referenced is State v. Kayward, a sexual assault case, where the defendant's incriminating statement was suppressed because the police fabricated a scientific report from an outside testing laboratory that allegedly found the DNA of the subject on the victim. Now, there are exceptions to this. There are 2 state Supreme Court decisions that have found misrepresenting evidence to a subject can be coercive. In 1979, the Montana Supreme Court, in this case of State v. Alley's, stated that, quote, lying to a defendant about how much is known about his involvement in the crime is particularly repulsive to and totally incompatible with the concepts of due process embedded in the federal and state constitutions. In this case, the police had falsely told the subject he had been positively identified and placed at the scene of the homicide. The second exception is the 2020 Hawaii Supreme Court decision in State v. Baker, in which the court said investigators should not misrepresent incontrovertible evidence in their interrogations, referencing the fact that in this particular case, the interrogator falsely told the suspect that the DNA evidence implicated him in the commission of the crime. The second topic I want to discuss under this umbrella of deception during interrogation is what social psychologists say. Quite a few false confession experts are social psychologists who claim that there are 2 sources of research that demonstrate support for their belief that lying about evidence causes innocent people to confess. That telling the suspect you have a witness when you don't, that you have their fingerprints on the murder weapon, that you have their DNA at the scene of the crime, all of a sudden makes an innocent person say, okay, then I must have done it. Let's take a look at what these sources of research are. The first source consists of cases in which the false evidence ploy was used in wrongful conviction cases, including some of the DNA exonerations. In his 2011 book, Brandon Garrett talks about his review of 250 DNA exoneration cases, which included 40 false confession cases, several of those which included lying to the subject about evidence. therefore suggesting that that deception about the evidence was the cause of the false confession in those 40 cases. However, as pointed out by Doctors Deborah Davis and Richard Leo, who are critics of law enforcement interrogation practices, quote, many and perhaps most of the interrogations in the cases Garrett reviewed crossed the line of proper interrogation techniques through the use of explicit threats and promises, feeding suspect crime facts, and other coercive practices. In other words, they're saying that it wasn't just misrepresenting evidence that might have caused the false confession, it was these aggravating circumstances that were present in almost all of them. In another research effort, the author, J.P. Blair, studied the first 110 DNA exoneration cases reported by the Innocence Project, several of which included the false evidence ploy, and reported that, quote, this study failed to find a single false confession of a cognitively normal individual that did not include the use of coercive tactics by the interrogator. And Mr. Blair pointed out the coercive tactics were the use of physical force, denial of food, sleep, or the bathroom, explicit threats of punishment, explicit promises of leniency, and extremely lengthy interrogations. As this research and several of the previously referenced court decisions have found, misrepresenting evidence in an otherwise proper interrogation does not cause innocent people to confess, but the aggravating circumstances within the interrogation certainly can create an environment conducive to a coerced and or false statement. Aggravating circumstances such as the use of physical force, denial of food, sleep, or the bathroom, explicit threats of punishment, explicit promises of leniency, and extremely lengthy interrogations. According to social psychologists, a second basis for concluding that misrepresenting evidence causes false confessions is found in laboratory experiments in which they have tested the hypothesis that false evidence leads innocent people to confess. The first of these studies, there are two primary studies. The first is called the Alt Key study, which required students to perform some data entry project and warned them not to hit the Alt key because if they did, the computer would crash. So what happened is as the students were entering the data, the researchers forced the system to crash and then falsely accused the students of hitting the Alt key and confronted them with a witness who said they saw them hit the Alt key. And in this context, a number of the students signed written confessions that they hit the Alt key. That's one study. In the second study, students were given a set of assignments and told that in some assignments they could collaborate with classmates, but in others they had to do it on their own. Collaboration wasn't allowed. The researchers, after the students completed all these assignments, the researchers then accused them of improperly collaborating on certain assignments, informed them they had violated university rules prohibiting cheating, and for some, tried to minimize the extent of their wrongdoing and encouraged them to take responsibility for their actions or to confess. The interesting part of the study is that half of the students who did these assignments were falsely told there was a hidden camera in the room which would be reviewed and eventually reveal their true guilt or innocence. When these students heard about the camera, 93% of the guilty acknowledged that they did have help on these assignments they were supposed to do alone. And 50% of the students confessed they also had help on some of these assignments they were supposed to do alone. However, if you read the fine print in the report, it turned out that these quote-unquote innocent participants did not confess to helping the other person at all. Rather, they were asked to sign a prepared statement to the effect that they improperly collaborated with their classmates, but they were reassured that if the hidden camera exonerated them, which of course they fully expected, they would not get into any trouble by signing the statement. This manipulation that these researchers engaged in by having them sign the statement would be comparable to asking a murder suspect to write a confession that he killed the victim, but assuring him if we didn't find his DNA at the scene, we would rip up the confession and destroy it and he'd be okay. As one court stated when discussing these two studies, because these two studies in this case were presented by the false confession expert of evidence, lying to a suspect can cause an innocent person to confess. When the court discussed these two studies, they said, quote, obviously these interrogations were not conducted by law enforcement, were not part of a criminal investigation, did not involve actual students, and did not present the students with a serious penalty. They went on to say, as a result, Professor Hirsch, the false confession expert in this case, readily admitted that these studies have limited value, which in the context of this case is an understatement. That's from the court. Even one of the authors of these two studies, Professor Saul Casson, has said one needs to be cautious in generalizing from laboratory experiments. At the outset, the third item we want to discuss are state laws that have been passed with respect to misrepresenting evidence when interrogating juveniles. Several states have passed legislation that prohibits law enforcement from lying to juveniles about the case evidence or making promises of leniency. As an example, here's what the Illinois law says. An oral, written, or sign language confession of a minor who at the time of the commission of the offense was under 18 years of age, made as a result of a custodial interrogation, shall be presumed to be inadmissible if, during the custodial interrogation, a law enforcement officer or juvenile officer knowingly engages in deception. And the law defines deception as the knowing communication of false facts about the evidence or unauthorized statements regarding leniency. Based on that background, here are the policy recommendations from Reid on the use of deception during an interrogation. Investigators should consider the impact that misrepresenting evidence to the subject may have on a jury or court's perception of their credibility. Investigators should be sure to check with their local prosecutors as to their views and recommendations regarding misrepresenting evidence to a subject, and should be familiar with court decisions in their jurisdiction on this issue. Specific prohibitions against the use of deception may vary within each jurisdiction. Investigators should not misrepresent any evidence to a suspect who acknowledges they may have committed the crime, even though they have no specific recollections of doing so. Investigators should not misrepresent any evidence when interrogating a youthful suspect with low social maturity or a suspect with diminished mental capacity or psychological disabilities. Investigators should not use deception to threaten inevitable consequences and should not fabricate evidence or lie about potential leniency. Given current judicial and legislative trends regarding the use of deception during an interrogation, investigators should adopt a general practice of avoiding misrepresentations concerning incontrovertible or dispositive evidence. For additional information on the procedures that we recommend for conducting interviews and interrogations, I would recommend that you visit our website, reid.com, go to the Investigator Tips, which is under the Resources tab on the homepage, and click on the article, Principles of Practice, How to Conduct Proper Investigative Interviews and Interrogations. Thank you very much for taking a few minutes to listen to this presentation.